Good morning and welcome to Cross-Border Enforcement of Consumer Law, Looking to the Future, an event organised by the University of Reading with the generous support of the Competition and Market Authority in the UK and the UNCTAD Secretariat. This event is part of our academic project of the same name that I have the pleasure to lead. The project brings together a team of accomplished academics and practitioners. I would like to take this opportunity to thank them all for all their work so far behind the scenes. Our project benefits from the financial support of the Policy Support Fund of the UK Research and Innovation Fund and the University of Reading. The academic project is feeding into the work of UNCTAD, the Working Group on Consumer Protection and E-commerce, and more particularly, the Sub-Working Group 3 on Cross-Border Enforcement Cooperation. You can find full information about our project on our website, www.crossborderinforcement.com. After today's event, please visit our website regularly to find a number of outputs that I hope you will find useful in your practice. Notably, we will have a report to the UNCTAD Sub-Working Group coming out, hopefully by the end of this month, as well as a number of other articles and blogs and news items that our project team is busy putting together at the moment. You can also sign up on our welcome page to the website for our newsletter to receive regular updates. This online conference forms an integral part of our research process, hearing from policymakers, enforcers, and stakeholders grappling with cross-border enforcement on a regular basis. Today, you will explore the global issues facing consumers, highlight the difficulties of global and cross-border enforcement, reflect on the value of international cooperation in enforcement, as well as investigate the design of international networks and cooperation frameworks, draw from other disciplines to explore systems that are more advanced, and hopefully we will open the discussion on the use of tech in consumer law enforcement. I would like to thank all of our speakers today, and of course our participants. Many of you are joining at fairly unsociable hours, given your time zones, because we have attendees from all over the world today. Many thanks also to the UNCTAD Secretariat for their support, and in particular, Teresa Moreira for opening our conference this morning. I'd like to also thank our guest panel moderators, as well as Catalina Goanta and Laura Add, who have generously given their time to organize the tech needed to welcome you all today. For now, I just need to hand you over to our Master of Ceremony for the day, Andrew Adley from the CNMA, who co-organized the wonderful lineup of speakers that you have in store. Andrew joined the OFT in 2001 and has worked on consumer policy at the OFT and its successor, the CMA, since 2003. Since then, he has advised on civil enforcement, the UCPD implementation, and written UK guidance on a number of key pieces of consumer law. He is involved in domestic consumer policy reform, as well as international consumer protection through the EU CPC, ISPEN, and more recently, the OECD and UNCTAD. Andrew is also the UK representative on the Bureau of the OECD's Consumer Committee. He will be guiding you through the day. But for now, from myself, Christine Riefer at the University of Reading, I'd like to thank you all for attending. Enjoy the day.
Well, thank you very much, Christine. I'm glad we were able to see you, even if only doubly virtually today. But Christine's really the reason that we're all here today. So thank you to her. I'm going to immediately hand over to Teresa Morea to introduce our session. So I'm sure many of you know her very well. Teresa is the head of the Competition and Consumer Policies branch at UNCTAD, with many years served in consumer and competition law enforcement, including heading the Consumer Directorate General of Portugal from 2010 to 2016, a member of the board of the Portuguese Competition Authority from 2003 to 2008. We are extremely grateful for her time to open our event today and for all the support given to the academic project that this is part of. So thank you very much, Teresa, and over to you.
Thank you very much, Andrew, for the kind introduction. Good morning, good afternoon, good evening. Thank you very much for putting together such an interesting conference. I would like very much to acknowledge and to congratulate Professor Christine Reeve for this organization, and thank you, Andrew, from the CMA of the UK and other partners for joining us today. I have a short presentation that I will now try to show. I hope you can see it by now. So let me just start to say that, of course, I am here and UNCTAD is very pleased to support this project because we are the focal point within the United Nations system for consumer protection law and policy, that we are also the guardians of the United Nations guidelines for consumer protection that were actually adopted in 1985, revised in 99, and lastly in 2015. And this is when the UN General Assembly approved a resolution, approved through a resolution, excuse me, the revised guidelines that really expanded the scope and actually included now a chapter on international cooperation that addresses a number of issues that will be discussed today. I also wanted to mention that since we held the first meeting of the Intergovernmental Group of Experts on Consumer Law and Policy in October 2016, the interest of member states representatives and relevant stakeholders has been so exciting, so intense, that we proposed the creation of informal working groups to allow us to have more detailed exchange, more continuous meetings and regular contacts with member states representatives and other stakeholders. And this is how the informal working group on consumer protection in e-commerce was born, and has actually remained very lively, not only with these 3 sub-working groups, but with a number of concrete projects. And the current project today is very much linked, as Professor Reeve mentioned, to subgroup 3. So we are very much looking forward to have a chance to see the report and see how we can take it a little bit forward in our discussions. I also would like to remind you that we have this interactive tool, the World Consumer Protection Map, that of course corresponds to a request by member states that we should draft a document on the legal and institutional framework. So this is a little bit still a work in progress, but this covers a lot of areas. And as you can see, it also covers cross-border enforcement cooperation. Right now, we have gathered information from 104 member states, and only 35 of these member states report that they have experience in cross-border cooperation, mainly, as you will see in the map. Let me show you also, mostly among developed countries. So there's quite a lot of room for improvements in this matter. I also wanted to mention that our recent research of December 2020 on international cooperation in consumer protection also focused on existing regional and international organizations and networks, and reviewed cross-border cooperation in consumer protection, mainly in enforcement, and found out that several obstacles remain that I'm sure will be addressed today, such as the applicable law and jurisdiction, but also even more practical type of issues such as language barriers, the lack of legal powers to address cross-border unfair commercial practices, and limited access to justice and redress. And these have been identified as, let's say, regular common challenges. I'm also like to just showcase other recent research we have done. Well, Professor Rifa contributed to this competition and consumer protection policies for inclusive development in the digital era. And this more recent paper on consumer trust in the digital economy would probably also be of interest to the audience. This is the case for online dispute resolution and was produced within the context of our technical cooperation project on digital infrastructure for consumer online dispute resolution. I would like also to, before I mention the upcoming events, to tell you, of course, that the COVID-19 pandemic really paved the way for increased international cross-border consumer law enforcement because of the rise of online transactions, especially well, since the pandemic outbreak. But of course, a trend was really increased that will tend to remain. And we have addressed several of these issues in our discussions in the IGE meetings in Geneva. Actually, last year in July 2021, we discussed consumer law policy and regulatory actions in response to and in the aftermath of the COVID-19 pandemic, and issues such as consumer trust in e-commerce, and of course, the need to promote more effective cross-border enforcement cooperation were identified as challenges and future areas for policy action. I also wanted to mention a little bit the regional cooperation aspect. I know that, well, Andrew has already referred to this. And of course, I think from our point of view, because our focus is on developing countries, as most of you will know, with our very large membership of 195 countries, we see a lot of merit in regional cooperation, either through formal lines, that is to say, through formal trade and economic cooperation agreements, or through informal arrangements, especially to allow developing countries to pool resources, to exchange information, to enhance knowledge, and even consider joint activities. So I did want to mention this potential of regional cooperation in whatever forms. And of course, also the interesting part, the beauty in a way of international cooperation, and it can encompass different types of cooperation, different regional partners and other representatives from relevant stakeholders. And we do see a lot of merit in this type of discussion. Because this is, well, this is coming out, if I may use the expression, from the works of UNCTAD informal working group on consumer protection in e-commerce. I would like also to draw your attention to upcoming events. UNCTAD organizes at the end of April its annual e-commerce week 2022. And the branch, my branch, the competition and consumer policies branch, is actually organizing 3 sessions, 1 high-level session on digital platforms, competition and data, and 2 consumer protection driven sessions on building online dispute resolution for Southeast Asian consumers in partnership with GIZ from Germany, and also trust in cross-border e-commerce, the case for consumer product safety in partnership with Consumers International. And of course, later this year, from 18 and 19 of July, we will hold the 6th session of the Intergovernmental Group of Experts of Consumer Protection Law and Policy, where we will hear of the developments of the working group on consumer protection in e-commerce. I certainly hope most of you will attend and contribute, and I wish you a very fruitful webinar. Thank you.
Thank you very much, Teresa. That's a really fantastic presentation. Shows just how much hard work has been done already in this space and how much more work is planned. But thank you very much for all of that work and for your presentation. I'm just going to briefly speak in a bit more detail about the work of the subgroup within the e-commerce working group that is focused on cross-border cooperation, just to bring people up to speed with what that work centered on and where it is likely to lead. So this is one of 3 subgroups within the e-commerce working group. There are 2 other pieces of work on misleading green claims, which is being led by Colombia together with MGP India, and on work on dark commercial patterns, which is being led by Kenya and Argentina. If there's interest in those, that might be something we can return to. I note that Boniface from Kenya, who's one of the BLUCO project leads, is speaking later, so maybe if people are interested in those projects, we can perhaps talk about it later. I'm going to focus on the 3rd working group, which is focused on cross-border enforcement cooperation, and that the work for this year is focused on a mapping exercise of the different legal consumer protection systems that are in place across the world. That's been led by my own organisation, the UK Competition and Markets Authority, but also in cooperation with the United States Federal Trade Commission and also Swedish colleagues. The Secretariat at UNCTAD has worked very hard with this and has circulated surveys and other bits of material in relation to each of those pieces of working. Subgroup 3C rather agreed in autumn last year to take forward Sweden's proposal for a survey of existing e-commerce rules, and that's the work that we're working on now, and will lead to a report in due course. That's looking at the rules. It's also looking at the landscapes and the systems around e-commerce, and that's been supplemented by some additional questions, notably ones put forward by India in relation to redress and online dispute resolution. Other groups, the other 2 that I've mentioned, have also taken forward questionnaires and surveys and webinars. So thank you to the member states that have responded to all of those surveys. We appreciate there's been quite a lot of asks from you, particularly in that the period in January and February. Just to focus a bit more on what's happened with that, with our piece of work within the cross-border cooperation group, we've had responses now from 13 countries. We've extended the deadline for responses to the 14th. I know that there are a couple more countries who we're hoping to hear from, even though we've gone past the extension deadline. But please do respond if you haven't yet to that survey. This event today is designed to support that project, so I'm going to reflect on some of the learning that's come up from the responses we've seen so far, although obviously it's only a very partial picture of the very large membership of the broader e-commerce working group, but also to try to find ways of discussing best practice, build some consensus around some of these challenges that Teresa's correctly identified, and to sort of identify some next steps for how we can actually enhance cross-border enforcement cooperation. The plan is that the UK will draft an outline of the report by the end of this month, which is looking very close at the minute, and it will then complete the report by June, which will give us time to discuss the report with the Secretariat and others ahead of the IGE in July that Teresa just mentioned. So what did the survey look at? It asked a number of questions around 4 topics. So one around domestic framework. So who enforces the law effectively? Which bodies within each country are responsible for public enforcement? Domestic legal powers. So what enforcement powers, what investigatory powers are available? Relating to one of the challenges Teresa mentioned earlier, I think very well. As I mentioned before, a section on consumer redress, so powers for public enforcers to require redress or support redress, and then some very specific questions around challenges, options and preferences for cross-border redress, including a global ODR mechanism, which I'll come back to later. Then the final section is on mechanisms for cooperation. So, for example, how easy is it for countries to share information and to cooperate practically with other enforcers? Looking at the responses we've received so far, there's different approaches taken to e-commerce differently, which are reflected in those responses. So several countries, including the United Kingdom, but also others, have multiple regulators. And you also often have splits between national enforcement, local enforcers, and then sectoral enforcement as well. So there's kind of quite different ways that these issues are being dealt with. Yes, and that's something that we'll try to map out as we get more responses in. That is one of the challenges that, for example, many authorities will have joint data and consumer protection powers. Some don't. So my own authority has joint competition and consumer powers, much like much matches the UNCTAD group, but colleagues are set up differently in different places, and that is a bit of a difficulty in neat mapping. In addition to that, there's lots of similarities between countries' approaches as well. These are much stronger where there are linguistic, legal, or sort of historical factors creating common systems. I mean, the obvious example would be the members of the EU, where there's a very strong sort of similarity between the legal structures, but notably in other regional cooperation as well. Most countries have got consumer and competition law. Many have specific rules on e-commerce or commerce carried out at a distance, but there are very different approaches on privacy and data protection, for example, where some countries don't have any detailed rules at all. On redress, which I think is increasingly sort of one of the interesting areas here. Again, there are very different approaches, and there are often different approaches to both, sort of domestic and international redress within a country. Lots of countries are taking actions to improve the ability of public enforcers to obtain financial redress when they take public enforcement action, but the ability to do so cross-border is limited. And I think it's really one of the reasons that this is a topic that I think we'll keep coming back to is however effective public enforcement is, however well resourced it is, which it certainly doesn't feel like at the moment. I'm sure there are feelings from other enforcement agencies. There's always going to be a limit to what public enforcement authorities can achieve, and so therefore it's absolutely critical that we enable effective private enforcement as well, and that is as low cost and accessible as possible, because wealth shouldn't be a precondition for people accessing their consumer rights. So, I mean, following some very, very sustained interest, particularly from our Indian colleagues, but also from other countries and from many of the academics contributing to the work of UNCTAD and more broader work on cross-border cooperation, there does seem to be quite strong general support for improved cross-border redress and even for an online dispute resolution system. But I think several countries have identified really quite serious difficulties in achieving this in practice. There's lots of very effective national ODR systems. We've heard from many countries, from South America, I think in particular, there's some really great online systems that are very effective. Portugal, the United States, all have very interesting systems that have different ways of approaching it, and I think there's a lot we can learn from all of those. I think increasingly we're hearing about effective regional systems. So, for example, within ASEAN in particular, there's obviously a very effective system in the CPC network within the European Union, and I think there's some valuable learning to be taken from that as well. But I think it's worth emphasising that there are very, very serious challenges in determining what is the applicable law in each given transaction. Also difficulties in obtaining binding outcomes for traders and for securing funding for such an ODR system. So there's answers needed on all of those. And it's still not clear whether global ODR is perhaps a suitable topic for a formal UNCTAD recommendation as yet, although I think that's something that we hopefully will offer a recommendation to the Secretariat at the end of this report, but very interested in people's views about that today, as it seems to be an issue that keeps coming back to our discussions as well. So both the public and private enforcement aspects. I was going to outline the sort of structure of the report at the moment, but I think given time, I'll move on from that. So just a few questions to leave you with before I hand over to the next session. So is it useful for us to spend more time and effort to providing a system for presenting different national approaches? So, for example, to build on the consumer protection map that Teresa showed earlier, that would take a lot of time and resource, because we'd need some resources, to actually put into updating the website and to working on that. But that's something that we might want to focus on. Interested in ideas about how the working group might take that work forward without resources. So, I mean, events like this where we're able to access academic economic funding to support the work of the Secretariat and those contributing to the working groups is really valuable, but interested in other ideas about that. Apart from these two issues about the high-level issues about cross-border cooperation and private redress, are there other specific issues and questions that people think we should be focusing on? Would it be interesting, for example, to revise the UN guidelines? Would it be useful to revisit the OECD toolkit, which we'll be hearing about in a later session, to bring those pieces of work together? That would be interesting. Are there other specific pieces of work that might be worth taking forward? Challenging question, I know, given money is always difficult, but would member states or others be prepared to fund some ongoing activities? For example, to set up more websites and redevelop websites that had greater functionality, that allowed people to search for different approaches to e-commerce regulation, for example, which I know our FTC colleagues were quite interested in working on. I guess this is probably the really key question from my perspective today, which is, are there clear and effective solutions to the three, or what I see the sort of three key challenges around online redress and dispute resolution? So applicable law, how do we get binding outcomes cross border, and how do we fund it? So if anybody's got answers to those, please do let us know. I suspect there won't be simple answers, but any thoughts are very much welcomed. I mean, at the moment, my thinking is that, I'm likely to recommend that the next year's subgroup activities focuses on taking forward solutions to those kind of questions, but I'm very open to different ways forward, and that will require discussion with the Secretariat and with the working group as well. And I guess one key question is, should we be focusing on global ODR, or would it be useful to think about non-binding dispute resolution at a UN level? Might that be a better way of taking forward an outcome? And then I guess final question, and sorry Liz, I know you're waiting to come in. How might the academic community and wider groups of consumer experts, so obviously the discussions have been largely between member states, but how might the academic community and others best feed into that? So anyway, thank you. Sorry to take a little bit more time, and I'll hand over to Liz now. Thank you for bearing with me.
Thanks very much, Andrew. Thanks very much, Andrew, for that. And yes, typically, just as I was coming on screen, that my son, who's off sick, and my cat came into the room, so I was set to very all ready to go, and then chaos happened. Anyway, welcome everyone to the very first panel session of today, and thanks to all the organisers and the supporters for making this event happen. The purpose of this first session is to set the scene for the rest of the conference by looking at the global context for consumers and for enforcers from a few different angles. So we'll be hearing from 3 speakers who are going to speak for about 10 to 15 minutes each. And once we've heard from them all, we'll be taking questions. And if you could please put your questions in the Q&A, if possible, with your name and the name of the organisation you're representing. And if it's directed at a particular panellist, if you could also say that as well. And as this is the opening session, and we'll be looking at challenges, but we also want to be thinking about possibilities and what next. So one thing I'd like to hear from you is what do you think is the top priority for consumers globally? And what's the best way to make progress and make that happen? So as you hear from this very excellent panel we've got put together, could you think about that in your head and how you might respond to that? So the top priority for consumers and the best way to make progress. Okay, right, I'm going to move on now to introducing our first panelist, who is Genevieve Sommier, and she is a professor of law at McGill University. Her research focuses on consumer law, the resolution of international disputes, and cross-border class actions. She's an expert in international law, a member of the International Academy of Comparative Law and the American Association of Private International Law. And she's also been appointed co-rapporteur for the Judgments Convention project at the Hague Conference on Private International Law. So Genevieve is going to talk about enforcement and effectiveness of consumer law and a study of 37 different countries. So Genevieve, over to you.
Thank you. And I'm going to share my screen. Please let me know if you see is that good? Yes. Okay. Well, thank you very much. I feel after hearing the first 2 introductory presentations that I'm going to be repeating a lot of what has already been said. But one of my final points was the need for more data. I know that's a constant request by researchers and policymakers, but certainly in this area, there's a lack of data, and it's difficult to come up with some good solutions, as Liz just mentioned, without the necessary data to back up the claims about what the nature of the problems are and what the solutions might be. So thank you for raising that as one issue and the continued need for doing it. And I would say, yes, I think it's worth continuing to do. But as I wanted to speak to you about this particular project that Hans Miklitz, who's also on the panel, and I participated in, which sought to get some more information specifically from people working in specific jurisdictions, which often is the best way to get this data, because government sources or formal sources are not always the most relevant. And just quickly, I went to see the UNCTAD map that you mentioned, and I did notice that for my country, Canada, for example, it's really incomplete because it only refers to federal law, whereas of course consumer law is provincial law, and therefore the information is just not accurate. So even when you get data, perhaps it's not the data that's really useful to the group or to researchers. And I know that Christine Rifa asked me to participate because she was one of the national rapporteurs for the UK for this project. It's already dated 6 years ago. It was International Academy of Comparative Law, where Hans and I led this themed research on enforcement and effectiveness of consumer law. Of course, it was from a national perspective, not the cross-border. So what I've tried to do with this presentation today is to try to migrate this domestic perspective into an international one. And as you'll see, I think that there are a lot of similarities. And so the question is, perhaps, where do we find solutions? I think solutions, in a way, could start domestically. And the question is whether they can be projected beyond. So this project covered 37 countries, which I think is more than you have had so far in your, if I understood correctly, you've only had 13 responses, but I know that these are different types of questions. And here I put a map. And so you see that we were able to get at least one country from each region, but of course an over-representation of the European states, which is not uncommon in these types of projects. They're reliant on self-identifying national experts. So we are able to go and get some in other countries, but it's extremely difficult in a lot of regions of the world to find local experts who to participate despite best efforts. So this allowed us to present a questionnaire, a very quite long and detailed questionnaire. And a lot of the questions that Andrew mentioned are the questions that we ask. So there's this recurrent recognition of the types of questions that are important to ask in order to eventually perhaps devise some solutions. So here I tried to put in a nutshell the questions that we asked. And of course, the primary, or the first one that has to be asked is to know better the national legal framework for consumer protection and the general design of enforcement mechanisms. And this is something that can't be overlooked because everything fits together, right? You can't understand how a particular jurisdiction approaches enforcement of consumer law without understanding its legal system, constitutional system, judicial system. And my example of Canada is a good one, right? If you don't know that a state has divided within its internal territories the competence over a particular law, you'll miss the picture of the consumer law in that jurisdiction. We also looked and asked about the number and characteristics of consumer complaints, because as we know, when you're looking at resolving concrete issues in people's everyday lives, you need to know what what those problems are. And here, the lack of data in a lot of jurisdictions was striking, whereas others have extraordinary data, very specific, detailed, year by year statistics about the number of complaints, the nature of complaints. And of course, all of that is related back to the first question, what are the enforcement mechanisms? And the more you have public enforcement mechanisms, the more access to data you have, because the collection of the data is done by a public body and often released and available for research purposes. And then we looked at the role of consumer organizations and external cooperations. I'm not going to speak on that because Hans is going to speak to that in his intervention. So really the key part of our project, and the one that is relevant for your work here, is the question of enforcement, and particularly the effectiveness of enforcement of consumer law. And so, of course, we looked, just as you're looking now, at private enforcement, that is enforcement of individual or private consumer claims, individually or collectively, typically through courts, so judicial redress, and public enforcement mechanisms, either directly by government agencies or through other types of complaint and dispute resolution mechanisms. So in other words, an individual complaint that could be resolved through a public mechanism that is not a court. And so typically these would be ADR and sometimes increasingly ODR. So all of these different types of ways of addressing and redressing, if you want, consumer issues, I think exist within the domestic jurisdictions that we looked at. Some very developed and therefore very effective. And we asked all of our reporters to give a grade, a subjective assessment, right, about how effective the enforcement of consumer law was. And we had several who gave, 8 or 9 out of 10, which is a very high grade, in particular Australia, Brazil, Sweden, and the EU. So I think the expected jurisdictions, but some gave very low grades, so under 5. And here are examples, and these are the subjective, right, evaluations of the individual experts. So Bulgaria, Uruguay, and Venezuela. So there's a very wide divergence, right, amongst those 37 states about the state of affairs in their jurisdiction and the ability to make real assessments, concrete assessments, given the lack of data. So just briefly before looking at possible solutions, I just wanted to give you a look at the comparative report findings. So from all of those domestic reports, Hans and I prepared a general comparative reports. And what I think was, and none of this is going to be surprising, right? In a way, it's the same thing that keep coming back over and over again, which so suggests either a lack of imagination on the part of researchers or policymakers, is that we haven't found ways of addressing these continuing recurring problems. And the issue is whether anything's different in the cross-border context. So it may be comforting to know that consumer law has been a priority of legislators in many states. So we noticed significant reforms, right? Even this was 5 years ago in large number of countries. So new legislation and legislation in draft form. So there's an increasing awareness of the role of law in responding to some of the concerns that are addressed. Everybody has a focus on consumer education and information, right? Going to public awareness. Again, whether that actually translates into public awareness is a different issue, and that's very hard to measure. And often we measure it by the redress, people who seek redress, but that's not necessarily the correlative thing to look at. Everywhere, the references to the high costs and delay associated with judicial proceedings. So I think that just confirms our view that anything that suggests that you have to go through courts to redress consumer complaints is going to be a losing proposition. And it's not necessarily related to the independence of the courts or the costs, the public costs of running them. It's simply because the value of consumer claims is often too small individually to warrant using courts. And in that sense, access to collective redress is often seen as the solution. Not a lot of countries at the time we wrote our report, outside of the usual suspects, so the US, Canada, Australia, New Zealand, and increasingly some in Brazil, and others have opt-out consumer class actions for damages, which are seen as, you know, either the high point or the low point of consumer redress. That's certainly something that's looked at, but again, a lot of countries have not accepted that or don't have a well-developed system. And of course, it's all tied into the way that lawyers are remunerated. And so it's impossible to detach these questions from a whole lot of issues that relate both to domestic law and policy issues.
Got one more minute, please, Genevieve.
Okay, then a huge challenge for the autonomy and independence of administrative agencies. So they're treated very differently. There's a mix of separate consumer versus part of competition law. And that's where I think the challenge arises, is the treatment of the economic and market-oriented competition view of things and the consumer protection, which are two very different visions. So are the challenges different? I think that the challenges are the same. The same problems exist, right, that we see in domestic situations. They are the same ones in the international cross-border context. So are the solutions different? I think the solutions are necessarily, at least on a continuum, right? So if ODR is the solution domestically, it's going to be the solution globally, but there again, the challenges versus the private or the public. The resources available, as we know, are limited. Online platforms are complex. They need constant oversight. And so let me finish with perhaps a question, and you'll maybe find that this is one that's unanswerable, but is there not a tension, a significant tension between facilitating e-commerce and, right, the view of helping consumers redress problems in e-commerce and the other priorities of our day, which are environmental and social equality. So if people are doing e-commerce because they want the lowest price, and I acknowledge this might be a global north concern, right? Why are we encouraging, why are we trying to make it easier if really it's going to have significant externalities that we are trying to redress in other contexts? Thank you.
Thank you very much. Lots of food for thought there. And I'm really glad that you brought in the environmental impact early, because it's something that we need to be holding in our minds as we go through this. We know consumer rights are not just about transactions and quality products. They're also about having an environment where our future generations can also consume, and that we have enough resources left for them to be able to do that and access the essential services. If I could ask the audience to keep putting any questions they have for any of the panelists into the Q&A, and also to remember the question we asked at the beginning, which you can pop into the chat. What's the top priority, do you think, for consumers globally, and what's the best way to make progress? Okay, I'm going to move quickly on now to our second panelist, Professor Hans Miklitz. He's a professor of economic law at the European University Institute, where he's been since 2007. Prior to that, he was a professor at the Berlin University of Applied Sciences and a professor at the University of Bamberg. Professor Miklitz has also advised government ministries in Germany, Austria, and the UK, as well as international organisations such as the OECD, UNED, and the European Commission. He's a member of the Expert Committee on Consumer Affairs at Germany's Federal Ministry of Justice, and his research focuses on European law, European private law, and European consumer law. So, Professor, we have 10 minutes for your presentation on the role of consumer associations in coordinated actions. So please take the floor.
Thank you very much for the occasion. In our context, what the key question is, can Europe, or can the development, the legal system, and the experience in Europe contribute to the debate? And is there something to take home? That is the key question that I want to answer. So the background to the question is 20 years of cooperation between the consumer organizations in the EU under the auspices of BÖG. BÖG is the umbrella organization of national consumer organizations in Europe, with advisors and observers also from outside Europe. So what I'm speaking of here and what I'm trying to deliver is 20 years of experience where we studied all this. We have been working together. There were different projects financed. I will not bother you with names. If you want, I can send you the links where you can find the reports that we produced in the last 20 years and where you can also find the necessary evidence from what I'm saying. So the overall approach of the EU has always been to use law and to harmonize the legal systems in Europe to create and establish a common background. And that is true also for the cross-border development. What does that mean? That means, first of all, that in Europe, we have common rules on jurisdiction. So on what is the competent court. Then we have common rules on the applicable law. So to put it in concrete language, we have a European law on international law, or we have European international law, means a common set of rules that govern the decision on what is the applicable law. And last but not least, we have also common rules on the execution. So once a court in the EU has taken a decision in one member state, under what condition can it be enforced in another member state? This looks all wonderful on paper. It's a fantastic academic playground for international private lawyers. You can write wonderful books and even make a career with all this. But the point is, what does it bring in practice? So here I would like to point you to two concrete examples, just as a warming up. The first was one where I was involved. It was a cross-border case on home shopping on sweepstakes. I think you know all know what sweepstakes are. You receive a letter. It's a bit less common today. Today it's much more via the internet. In the old times it was via a normal mail. You got a letter and the letter was saying, you have won $50,000. And all what you have to do is to sign here and then you get it. As we all know, things are a bit more complicated than this, and there was a lot of cheating around and so on. So that was a case where I was involved, and the company was sitting in, I think, in Malta at that time, and the consumers concerned were those in France and in Germany, and it was a true cross-border case. And the other one, I'm very happy that Andrew Hadley is here. So the Office of Fair Trading in the old times, some 15 years ago, roughly, tried to, in the famous Duchenne case, tried to do a similar thing. So that was a company located in Belgium, and they sent out letters to UK consumers exactly on similar issues, the sweepstakes, you have won a prize. And what the Office of Fair Trading wanted to do is to set an end to this, and they went to court in Belgium. Everything was tested, the applicable law, the jurisdiction, and the enforcement. That was, I think, a decisive experience for consumer institutions in Germany, because the outcome was, to put it bluntly, a disaster. The legal system is just not shaped, not even in Europe, not even in a relatively homogeneous environment, to deal with cross-border collective action. The whole system in the EU, the one on jurisdiction, on applicable law and execution, is designed for individual litigation. But even in individual litigation, we don't have much cases in the EU. And in collective action, we have a good overview. perhaps not perfect data, but we have a good overview, as you can see if you want, in the different reports that we produced. And the result is that consumer organizations in Europe, and agencies too, they largely, by and large, refrain from engaging in cross-border action, just because of the legal complexity of the many open legal issues that are there. As I said, a wonderful playground for academics, but of very limited importance in practice. What is the alternative? And I will take the last couple of minutes that I have on the alternatives, because there is something good or something promising to report in the end, that the consumer organizations were able to develop, and that was what they termed and called themselves coordinated action. Let me give you an example that you can equally find on the internet, because Böck published a report on Dieselgate. I think I don't have to explain what Dieselgate is. I take it for granted that you know the problem that German car producers in particular have cheated buyers on the emission of their diesel cars, and that triggered action not only in Europe but worldwide. So there were cases in the US, as you know, but there were also cases in China, and I have no complete map like the one that Geneviève demonstrated you in our analysis of the different reports. So I don't know where and in which country all these actions have been taken, but I can report what happened in Europe, and that is documented in the report of Böck. What does coordinated action mean? So in the case of Europe, it means that there is one body, and that is Böck, the European Umbrella Organization, that is working as a catalyst, very much like the OECD in an international environment, not taking action, but bringing the people together, setting up the forum in which the consumer organizations from the different member states can communicate and can develop joint strategies. So you may go very much into detail. So the first decision is where to invest scarce resources. Yeah, and obviously it was one of the Dieselgate was one of the issues where most consumer organizations and agencies in Europe felt something has to happen. But coordinated action is more. That means in a perfect world, it would mean to launch litigation all over Europe at the same day in 27 countries. And then it would mean to constantly monitor what is going on in the different courts, in the different countries, and to report back and exchange information, so to initiate a learning process. This is easily said. It's difficult in practice, as you may imagine, but in the report that Böck produced on Dieselgate, you will see that there are some promising results that can be put further. However, as Geneviève said in the beginning, all these activities are subject to financing. And in the case of the EU, the European Commission has dedicated a particular amount of money to Böck that can be used for these kind of coordinating activities. So I could imagine a world, and I could imagine cross-border litigation around the world, also far beyond Europe, that could have an impact in particular key problems. that we all suffer from, because our consumption society is unique, as we could discover in the Dieselgate scandal. Thank you very much.
Thank you very much, Hans, and thank you very much for sticking almost exactly to the 10 minutes. That was a very, very good job. And yes, I think Dieselgate's really interesting in that it, as well as the European commonalities, there are obviously cases being brought in Chile and other countries as well. So it could truly be one of an early global coordinated action, not just at the European level. So we're going to move to our final panelist now. It's Jason Freeman, who's the Director of Consumer Law at CMA, the UK Competition Authority. So he manages a team of lawyers who advise on consumer legal issues. He's worked on all sorts of areas over the years, including enforcement against secondary ticket sell platforms and social media influencers. So things that are becoming quite big in the digital world. Lots of his cases have pioneered use of the UK's Enterprise Act, which had redress powers for consumers and have managed to secure millions of pounds in damages for consumers. And then internationally, outside of the UK, he's led the EU CPC joint action on car rental providers, and he takes part in various forums such as UNCTAD, ICPEN or ICPEN, and the OECD. So Jason, you're going to be talking about the role of public enforcers in protecting consumers in digital markets, and I'd like you to take the floor, please. Thank you.
Thanks very much indeed. I'm going to attempt to share a screen because I think everybody likes a slideshow. So here we go. So yeah, so I'm going to say a few words about the role of public authorities and you know, to share some of the insights perhaps that I have. And I should say I found it very interesting to hear the previous panelists talking about their experiences and insights as well. And certainly I agree that coordinated actions are probably much more effective in many ways than you trying to take cross-border action yourself as an enforcer. And that's one of the things which I'll probably be talking about, assuming I have time. So why are my slides not moving? Oh.
Can you put it on
Oh, there we go.
from beginning?
And it should say what are digital markets now, so hopefully hopefully it's going to work for us. So digital markets, in a way, I think digital markets cover the whole of the economy now. There's so much which is going on, both either it's on the internet or it's a trader who's operating in your country, who's a big multinational company operating across multiple markets. You know, that gives rise to many of the same issues to where it's a purely digital market. So I don't know how helpful it is to describe things as digital as such, but obviously where you're dealing with digital selling, so internet selling, the additional skill that enforcers need is technical ability. And I think we're going to have some presentations later about technical ability. But in the CMA, for example, we have invested quite a lot of money and time and skill in building technical ability. So whether it's the ability to understand how websites work and to research what's going on the internet, or it might be to do with behavioral science and how consumers behave when they're interacting with websites, getting insights into things like dark nudges, and similarly complicated topics. Enforcers increasingly need to have this panoply of skill, which enables us to really understand what's going on. But also, and this is the thing which I think probably we want to focus on today is international reach. Enforcers need international reach. So that's whether it's the ability themselves to reach into the pockets of a company and take out redress for consumers, or it may be to ask an ally overseas to do something like that, to assist in some way, whether it's to get evidence or to help us to find a solution. But I think it's important also in this discussion not to assume that everything is a problem. So there are big benefits as a result of the increased globalization of trade, you know, around choice, around cheaper prices, and you know, the fact that usually things do work out well. I think it's fair to say usually markets are working reasonably well for consumers and people are generally happy. You know, you make your purchase on the online marketplace, it arrives, you're happy with the quality, you're happy with the price. I think that it's probably fair to say that that is the general picture for people. But obviously where things go wrong, that can be a problem. And where things go wrong, the role of the enforcer is to try and find solutions. And sometimes the solution is about making the the ecosystem work better. So for an example I wanted to give on this is to do with platform responsibility. And one of the features which the CMA and before it the OFT works on was trying to help platforms to understand better how they could make the market work well. So for example, a platform, if you think of a marketplace, for example, you know, like Amazon or eBay or one of the other marketplaces, like a secondary ticket marketplace, or car rental marketplaces, many of these which I've worked on, as you've heard already. Sometimes the marketplace may see itself as a sort of passive participant. You know, it creates a playground and everybody arrives and plays in the playground, and either things go well or they fall off the swing and hurt themselves, and then that's really sad, but nothing the playground operator can do. But actually, we think that the position is somewhat more complicated than that, in that the platform does have responsibility. Often the problem may, for example, be to do with the information that consumers see and which the sellers on platforms upload, and the platform could improve the templates, for example, or it may be that they could give a little nudge to sellers to say, you know, you need to mention this at this moment, or it may be they could check things. So for example, they could check whether the seller really exists, or they could make sure that the information which the seller is giving about itself actually corresponds to the payment details that the seller has given to the platform to pay for its services. Sometimes the platform could do some more research, you know, into does this I don't know, with a car rental company, you know, do the prices match up to what the seller is advertising on the platform? Sometimes it's about monitoring compliance, you know, using technology or algorithms to have a look at what's going on. So one of the things which we asked Instagram to do, for instance, was to check for unlabeled advertising, unlabeled endorsements by influencers on Instagram. And they have the technology we considered, and they could do that. So we wanted them to do that sort of monitoring. And then, of course, driving compliance, you know, checking up on traders and saying, look, this doesn't look right. According to our research, you know, this information is not correct. You need to correct it. And perhaps sometimes providing redress. So sometimes platforms can provide redress. And, you know, in the UK, there is there are some legal frameworks which facilitate redress. So under the Consumer Credit Act, for example, the payment intermediary who operates the credit card has a legal obligation to step in certain circumstances where consumers don't get the product that they're expecting. And the consumer can pursue their credit card company jointly and severally with the seller. So creating that kind of framework which benefits your consumers can be a big part of finding a solution where you've got an international problem where it's just hard for you to reach the seller who has provided you with the contract and maybe not provided you with the good. And of course, in all of this, we are always navigating the legal framework which exists. So one of the legal frameworks which has existed in the EU for a long time and which the UK has inherited is to do with e-commerce and hosting defenses and, you know, the sorts of things which platforms sometimes say, look, I don't have to do anything because, you know, I've got this legal framework. And often we've taken quite a robust view on that. And it's important that enforcers are vigilant to understand these legal frameworks and to really test whether they give intermediaries a way out, for example, or whether it in fact could be construed in a more limited fashion. So, you know, we think, for example, that the hosting defense in the EU and in the UK doesn't apply where the platform is simply viewed as a trader, and they have obligations under the Unfair Commercial Practices Directive to be professionally diligent, not aggressive, not misleading, and so forth. So, you know, that's one of the things which we do. We try to find solutions. And the important thing in this is that in the consumer's marketplace, there must be a level playing field. Competition must be fair. So it's really important that businesses don't get an advantage by locating themselves physically outside of the consumer's jurisdiction and using practices which perhaps are not lawful in the consumer's jurisdiction, but may be lawful or may not be lawful in the trader's jurisdiction. And being able to close that gap is very important. So I'll move on to think about some of these challenges quickly around modern enforcement. So when we're thinking about dealing with that gap, so the trader is in one country, the consumer is in the other country, the trader maybe doesn't feel like complying with the consumer's law for whatever reason. Well, the enforcer in the consumer state needs to find a solution because that's where the problem is being suffered. And inherently, so often, this enforcement is cross-border, but it's importantly collaborative. We're thinking about, well, how do we work well with the enforcer overseas? So if we imagine a situation where there's a trader, for instance, in Germany, and they might be selling a product through their marketplace to a British consumer, it's a situation which we might be dealing with, we have a problem, don't we? We think, well, how can we get the evidence from that particular trader? It may be that they have a complaints database, but it isn't actually in Germany either. It may be in Ireland. So how do we get the complaints database to find out, what other problems that trader may have been causing? Or it may be that their website is being managed by another business in Spain, for example. It may be that the payments are being routed through the USA, or they've got a parent company in the USA, for example. In all of these situations, we need to work well with the enforcer in in each of those respective countries, so that we can get the evidence that we need, so that we can we can take action to secure the redress which is necessary to bring about justice for consumers in the UK, and to level the playing field so that that business doesn't get an unfair competitive advantage by not complying with, in this case, UK law. And of course, the same situation is replicated all across the world, because often it can be a British business who is not complying with a piece of legislation in another state. And how do we solve that problem? So this is very challenging, isn't it? Because there are lots of these challenges to cross-border cooperation, and I set some of them out here. So first of all, there is a significant problem with sharing confidential evidence. We know, for instance, that we've got complaints about this business, but can we share it? Can we share the consumer's data with an overseas authority? Can we share? Can we get the information back from the overseas authority about that trader? Do we feel comfortable about sharing that? Are the legal frameworks in place which enable us to share that information? And sometimes actually there aren't the legal frameworks in place. It may be that the technological system is not in place. Sometimes we may be dealing with an enforcer, and their IT systems are not compatible in a way with our IT systems, and we can't share the confidential information in a secure manner. So those can be practical difficulties as well as legal difficulties, which relates to whether the other enforcement counterpart can keep the evidence secure. Or sometimes actually it may be to do with transparency in government. Sometimes enforcers have very robust transparency rules, which mean that they have to disclose information, and there can be a mismatch between the transparency rule in one country and the transparency rule in another country, meaning that if you give some information about the fact that you're investigating a business to an overseas counterpart, it may be that they will face the pressure, maybe legal pressure in their jurisdiction to release that information to the public, and that could be a problem, couldn't it? Then, of course, we're thinking about, well, what about the investigative powers? Do we have the powers to assist each other? And there's two problems here. One is, well, does the overseas authority have the power? Do you have the power that's necessary in order to actually carry out investigations in a high-tech world? So do you have the power to carry out a test purchase, for example, or do you have the power to go on site and take evidence from a website server, and can you do that? And can you use that power where it's not your own consumers involved? It's not your investigation, it's an investigation being run by an overseas authority. And sometimes there are real difficulties here because the powers don't exist, or the trigger for using the power requires you to have a complaint from a consumer in your jurisdiction. You don't have that because, of course, some business models involve a business operating, carrying out their business operations in one state, but only targeting consumers in a different state. And there's nothing wrong with that, but it can create, it can be used as a means of circumventing legal protections, and that could be the effect.
2 minutes left, Jason. Thanks.
Thank you. Yep. Then we have the issue of when can we enforce the law to protect each other's consumers? So this is another profound difficulty, that sometimes enforcers can only enforce the law where it's their own consumers. They can't enforce the law against traders in their jurisdiction to protect an overseas consumer. And that's a problem, of course, isn't it? Because in that situation, I'm the enforcer where the consumers are. Let's say, well, I'm struggling to get into the overseas jurisdiction because I don't have VIRAs to appear I don't have standing to appear before their courts, perhaps. I can't go there. That would be some kind of interference with the sovereignty of that country. So there's my problem. So I ask the overseas authority, well, can you enforce? And they may say, well, no, I can't enforce actually, because none of my consumers are complaining. Or it may be they say, well, you know, this trader is not breaking any laws in my country. They're only breaking laws in your country. So you're going to have to deal with it. So, you know, this leads to a real practical difficulty. And actually in the UK, we've sought to solve that by making sure that the law gives us the power to enforce British law wherever the consumer is. So if the consumer is overseas, if the consumer is in the UK, that's not intrinsically a problem. We can still get an order against a UK trader if they're breaching UK law. So we expect them to do that as a minimum. And the last problem, of course, which is the most difficult to solve, is resolving conflicts of law and jurisdiction. There is probably no solution to this problem because there will always be differences of law. We're never going to have fully harmonized law across the whole world. Even if it's achieved, for example, within a regional trading network like the EU, even there are still conflicts of law and conflicts of jurisdiction which have not been fully solved. So we have to have a cross-border enforcement mechanism that works, notwithstanding conflicts of law and jurisdiction. And that sometimes may mean that there is a bit of uncertainty for businesses. It may be there are overlapping laws. You know, they have to comply with laws in the UK, laws in Germany, which may be slightly different. Yes, this is a practical difficulty, but we have to be able to have a system which can work its way through that and not be tripped up because you know, we don't have exact harmonization. Having said that, of course, I think one of the things which could be done is to have more discussion about greater harmonization of substantive law in international fora such as UNCTAD, and it may be that some targeted harmonization, for example, on cooling off periods, could be useful. Anyway, so that's those are the challenges, and I think looking forwards, as I say, the legal frameworks are not complete on this area. I think Hugh's going to talk about this a bit later on, but the OECD has worked on and produced a toolkit which seeks to give some guidance to governments when we're trying to solve some of these problems. You know, to think about, well, how can we make sure that our legal systems do work as well as they can? Of course, we haven't sought to resolve the conflicts of law and jurisdiction issue. But as I say, I think it's important that our future enforcement models don't rely too heavily on legal consistency. They have to be able to work where there are conflicts of law, applicable law and jurisdiction. And we need to learn how best to work well with each other to navigate those. And enforcement of judgments, I think, is the last area which is going to be difficult. So if I get a judgment in the UK, can I enforce that judgment in the USA, for example? Who's going to help me to enforce that judgment? You know, there may be difficulties around doing that because there isn't a treaty system in place, perhaps.
Jason, we need to wrap up now, so we've got time for some questions, if that's okay.
I have, yeah, that's my very last point. Maybe there's no system in place to enforce that judgment. So I think that's the other area which it's important that we try to resolve in international fora, such as UNCTAD, OECD, and so on. How do we go about securing enforcement of those judgments? So that was all. Thanks very much, everybody.
Thanks very much, Jason. I've got some questions coming through, which I'm going to go to straight away. Before we go to the break. So there's one from Pierre Horner, who's a PhD student in law, and he has a question for Genevieve, which is around, I'm going to try to summarize it here, that eventually, from your report findings, it looks like we'll need to have a much more interdisciplinary approach between the classic private international law principles and then the application of some of the UN guidelines, which are about cooperation between public consumer enforcement agencies. And are you aware, or is there any approach or solution that's been put forward for how we could bring these two together that's out there so far?
Well, thank you for the question. And I think a lot of the things that Jason ended up with are relevant to that. Whether there are any solutions, I wish there's some work that's being done. Yes, of course, but the biggest challenge is the fact that private international law, and the word private, right, is meaningful in that sense. It really isn't or hasn't been conceived of classically to deal with anything to do with public enforcement, right? It's this divide between private, the contract aspect, even collectively, but you're still in the contract dimension versus enforcement of public law through enforcement agencies. Although, of course, enforcement agencies, right, if the contracts are regulated through consumer law, they may have powers to sanction and perhaps, right, even to provide damages. So but that's very variable across the different jurisdictions. So I think the interdisciplinarity runs deep, right? It has to be a reconceptualization of private international law to deal with the public enforcement sides. But at the same time, that's also, again, focusing on the idea of individual consumer redress in the contractual sphere, which, as I tried to say, really has been recognized as being perhaps in the current system, right? It really isn't the way forward. That's not going to get you anywhere because there are too many obstacles in the way. So to imagine cooperation, it has to be on a different level. It can't be looking at solutions through applicable law and jurisdiction. To me, that's just a non-starter. It's not going to help. And so it has to be completely reimagining how we can address these problems. And that's why, sometimes the idea of ODR, which is not necessarily based on domestic law or domestic jurisdiction or enforcement, because if you have particularly consensual, right, in the sense that the parties can agree to a resolution that doesn't necessarily have to be based on specific law. Of course, that might put the consumer in a vulnerable position because they can't invoke specific rules, but that seems to me to be the only way forward. And examples such as, the Amazon, PayPal, eBay, the ones we've all heard of, as long as there's a feeling that the resolutions are somewhat fair to the consumer. But there are also a lot of very small traders in e-commerce, right? And so the idea that it's just these large multinationals pressing the consumers, I think, has to be rethought in the nature of the goods or services that are being traded. So of course, need for more interdisciplinary breaking down the silos between the disciplines, but also just recognizing that these are old categories that don't fit with the reality of the digital e-commerce market and the global market.
Absolutely. Thanks very much for that. And I have a question to Jason. You talked a bit about cooperation between enforcement. Can memorandum of agreement be used in the interim before more solid things are set up to enforce on each other's behalf? Is that something that you've had positive or negative experiences with?
I think the real difficulty is that even if you have the best will in the world, if you don't have the power to investigate or to share information, then you end up hitting a brick wall on that. So I think, it's great to do that. And of course, one of the other difficulties that authorities have is having a shared understanding of priorities. And authorities sometimes don't wish to prioritize for good reason, an overseas problem because it's not going to protect their consumers. And they say, well, it's not a problem for us. So some MOUs can be helpful in that respect, where it creates an expectation that you will do some work to assist overseas authorities. So yes, it is assistance in that respect. But if you don't have the power ultimately to do anything useful, then there's very severe limits to the benefit of an MOU.
Yeah, that's a great point. And I think the point on priorities is going to be picked up in a later session. Because we're about to go to the break, I'm just going to put the final question to Hans. Dixon Lungu from the Zambian Competition and Consumer Protection Commission has asked what are the challenges to cross-border enforcement and what's possible solutions? And I think we've covered a lot of that. I just wanted to hear from you, what do you see as the biggest challenge in the digital era? Could you just take yourself off mute, Hans? Thanks.
To my mind, the biggest challenge is to overcome nationalist thinking. That in practice, what I experienced is that the enforcement authorities, whoever it is, or consumer organizations, they are all mainly concerned about their consumers. Yeah. Whereas, and there is a total mismatch between the often worldwide dimension of a particular problem, yeah, because that is just the effect of globalization, and the thinking in we have to do something for our consumers. That is the biggest problem. And even when you, let's say, to be very concrete, when an agency is attacking Facebook, yeah, for whatever reason, this has automatically a transnational dimension. And I think there is a lot to do to make this clear, and also to communicate and to think of new strategies, how such an experience could be used. Yeah. And that is something where, let's say, law, I would argue, is playing a backstage role. Yeah. It is useful, you need it. Yeah. But there's a lot to do in terms of bringing many skills together.
That's a great answer and a great way to finish the session. I think as well as hearing about the MOUs and process and data, there's something that we're hearing from this panel about a real cultural change that's needed, and thinking about how we consume and then how we deal with consumer problems, and an opportunity to reimagine what that could look like, which we'll be looking at throughout the day. So I'm going to bring the session to a close. Thank you all very much for participating. And if you could, we're going to take a short break now, and if you could rejoin at 11:35, that would be fantastic. Thank you very much.
Welcome back to our event. Thank you all so much for your participation so far. That's been really fantastic. Thank you all very much to the speakers. I'm just going to introduce the second session now, and just to encourage you to enter your questions in the into the Q&A, and then we can think about how to deal with them later on. So I'm extremely privileged to introduce a really incredible panel. Really grateful to all of them for participating. And I think just to build on the comments at the end of the last session, I think the obvious way of transcending our nationalist preoccupations that Dr. Mittlitz was rightly focusing on is to work within transnational organisations, within multilateral networks such as UNCTAD, and we're going to hear from several distinguished speakers about their experiences, both general and specific within those networks. And the idea here is to think about how we can build on that experience and make our cooperation even more effective. So I'm first going to introduce Brigitte Akokka, who joined the OECD in 2005, and she is now the head of our Consumer Policy Committee. She's responsible for the activities of the Committee on Consumer Policy and the Working Party on Consumer Product Safety, on empowering consumers in the digital and the green transition. Prior to joining OECD, Brigitte practiced as an attorney in international law firms in Brussels and Paris. So thank you very much for your time today, Brigitte. It's really appreciated. And over to you to start your presentation when you're ready. Thank you.
Thank you so much, Andrew, and thanks for having me today. It's a pleasure to be here to provide a brief overview of the work that the Committee on Consumer Policy has basically been developing to facilitate and enhance cross-border enforcement cooperation efforts. Basically, this work dates back to the adoption in 2003 of the cross-border fraud recommendation from the OECD, which calls basically governments to work towards establishing effective domestic systems, enhancing notification, information sharing, and investigative assistance between countries, improving the ability to protect foreign consumers from domestic businesses, as well as to protect domestic consumers from foreign rogue traders, to ensure effective redress, and to cooperate with the private sector. In 2006, the committee issued a report evaluating the impact of the recommendation. And this report found that countries had made significant efforts to combat cross-border fraud at domestic and international levels, but that there were still a number of challenges to be addressed to improve cooperation. Another hallmark that I wanted to mention today is the 2016 OECD recommendation on e-commerce, which also contains a number of principles on cross-border cooperation, promoting, for example, joint initiatives at the international level, improved consumers' authorities' ability to investigate and take action, as was just discussed by the previous panel, and use of existing international networks and bilateral or multilateral agreements, as well as arrangements for mutual recognition and enforcement of judgments. To support a review of the 2003 recommendation, and as part of the work on implementing the 2016 e-commerce recommendation, in 2017, the committee started reviewing consumer authorities' activities and their powers regarding cross-border cooperation. In 2018, a report was released summarizing the responses from 31 countries to a survey of consumer authorities and powers. What the results showed is that at the domestic level, most consumer authorities have some form of investigative powers. most have powers, for example, to compel documents or files or testimony from a business or third parties. But in order to exercise these powers, authorities in some countries need to obtain approval from a court. Consumer authorities have a variety of tools to take action against rogue traders. For some, enforcement actions may require, however, judicial approval. The most common actions that were mentioned in the responses that we received were publishing notice of a violation by a rogue trader and fines. Now, looking at the international framework for enforcement cooperation, many countries reported in the survey responses having improved their frameworks to cooperate with consumer authorities and other countries against cross-border fraudulent and deceptive practices. As shown on this slide, all but 2 countries had legal frameworks or other arrangements with foreign authorities to enable cooperation. Many countries also indicated that they had increased collaboration through existing international networks, such as the ISPEN and the EU CPC, as well as through bilateral arrangements, such as MOUs. This slide indicates that consumer authorities are generally equipped with the ability to share certain types of information with their foreign counterparts, particularly publicly available information on specific business and on expert opinions. However, a number of countries limit the sharing of consumer complaint information, for example, information obtained through a compulsory process due to the need to protect business secrets and the confidentiality of information. Further, in many countries, consumer authorities have relevant cross-border enforcement powers. The left figure shows that in all but 5 countries, consumer authorities can enforce laws against domestic businesses harming foreign consumers. However, the survey also indicated that there was a considerable difference in the conditions for such action, which may sometimes depend, and in some countries depend on, for example, the existence of affected domestic consumers. The right figure indicates that 77% of respondents can enforce their consumer protection laws to protect domestic consumers against foreign businesses. However, in some countries, the ability to take action may be limited and may depend, for example, on the effect of the business conduct on consumers. The survey further suggests that the role of consumer authorities in facilitating redress is actually mixed. As shown on this slide, 50% of respondents reported having the ability to provide remedies to foreign consumers, but that is leaving 48% of respondents who are not able to provide those remedies to foreign consumers. A number of countries reported having successfully provided remedies, though, such as monetary redress to foreign consumers in certain types of cases, but several noted that it is still very legally difficult to do so. And a minority of consumer authorities were not equipped with the powers to provide remedies, even actually to domestic consumers. The most important barrier to cross-border enforcement cooperation was a lack of adequate resources, with around 70% of countries reporting inadequate resources were always or frequently a barrier. But also around 90% of countries identified insufficient legal authority as one of the main barriers, including legal limitations on the types of information that could be shared, the kind of enforcement actions to be taken against foreign businesses, and the conditions under which such cooperation can take place. The survey report concluded that while the 2 recommendations of the OECD played an important role in establishing principles to facilitate international cooperation, and that significant progress has been made, more efforts are definitely needed, including in particular on notification and enforcement activities such as information sharing and investigative assistance. In 2018, we actually also conducted a review of the cross-border fraud recommendation, which similarly concluded that the text was still fit for purpose, but that it required better implementation, which is why in 2019, we organized a roundtable to share information about the legal schemes to enhance enforcement cooperation. And this was the view, the idea was to provide countries with the resources, the tools, and a strategic roadmap to engage in cross-border cooperation. And so the committee, in consultation with the ISPEN, developed what has already been mentioned by Jason and will be presented by the CCP chair right after me, the implementation toolkit on legislative actions for cross-border enforcement cooperation. I just wanted to note as well that we are now finalizing a report on the implementation of the 2016 OECD recommendation on e-commerce, which basically is showing that 70% of respondents have conducted a review, adapted or adopted their laws in this in this context, and that around half of them have granted more powers to consumer authorities. I wanted to finish by saying that beyond looking at the legal frameworks and enforcement cooperation among countries, I just wanted to say that at the OECD, we have done a lot to cooperate with other international fora in the consumer policy area. For example, we've held a number of joint events with the ISPEN and the UNCTAD, and in particular as part of the development of the implementation toolkit that I just mentioned. With ISPEN and UNCTAD and FIAC representatives, we have had a great discussion at our June last year International Consumer Conference, where we had a dedicated discussion on enforcement cooperation and the toolkit. We also had regular collaboration with our colleagues in the ASEAN on e-commerce and product safety, and most recently on sustainable consumption. And through this cooperation, we have strived to ensure consistency in standards. And I just wanted to mention that through this work, together with UNCTAD, for example, in the UN guidelines, in the revised version in 2015, there was a reference made, there is now a reference made explicitly to the OECD 2016 recommendation on e-commerce and the 2003 recommendation on cross-border fraud as key recommendations for global cooperation. So perhaps I should stop here. I would be happy to say more about our work on international cooperation, including in particular also in an area that I haven't really talked about, which is product safety and the global recourse portal that we have to enhance enforcement cooperation, but I'm happy to pause here. Thank you for your attention. I think you're on mute, Andrew.
Sorry, thank you very much. Thank you so much for your presentation. Fantastic overview there, and well done for keeping to time. Really interesting to hear at the end about the increasing cooperation between the different networks and the different groups, because obviously as we need to cooperate as countries, the networks in which they're cooperating also need to cooperate increasingly. So that's really, really positive to hear. But thank you all very much. Thank you very much indeed. I'll now hand over to Hugh Stevenson. He is the chair, as Brigitte said, of the OECD Committee on Consumer Policy. He's also Deputy Director for International Consumer Protection at the United States Federal Trade Commission, and he leads the team that coordinates the US agency's international consumer and privacy work. He's participated in the OECD's consumer policy work for more than 2 decades now, and for between 2008 and 2016, he served as the US Vice Chair of the OECD Working Party on Security and Privacy in the Digital Economy. He's worked on US and FTC delegations for numerous international organizations and represented the US in negotiating the 2015 revisions of the United Nations Consumer Protection Guidelines. So Hugh, I'll hand over to you, and I understand we're operating the slides for you. Just for the benefit of Laura, could I just ask you to announce when you want us to move the slides on, please? But thank you very much for your time, and over to you when you're ready. Thanks.
Thank you very much, Andrew. It's a pleasure to join in this conversation. It's an issue that I personally have been working on for many years, and I consider crucial for the future of consumer protection. What I'm going to try to do is to build on Brigitte Koka's presentation on the OECD standards on cross-border enforcement cooperation, and emphasize a point she did make, which is that I think the UN consumer guidelines also refer expressly to both the 2003 cross-border cooperation guidelines that she referred to, and the general e-commerce guidelines, which also have provisions on cooperation. So the good news, I think, is that we have a large consistency of approach. We look at the UN guidelines, we look at the OECD guidelines, we look at other documents that are out there, the African Dialogue guidelines on enforcement cooperation, for example. So what I'm going to talk about is more specifically the committee's key recent output in this area, which was the toolkit on legislative actions for consumer protection and enforcement cooperation. And what this addresses is the issue that Brigitte noted of the legal limitations that we face in consumer agencies on cooperating. And it represents the culmination of a lot of work looking at what's been done and what needs to be done still to improve the enforcement cooperation. Next slide, please. The toolkit was released at the committee's International Consumer Conference in June of last year, which celebrated 50 years of consumer policy. And as Brigitte mentioned, one of the sessions focused on this important issue of cross-border enforcement cooperation. And should note that the session is online and you can watch it then if you're interested. Next slide, please. This is the toolkit, and the toolkit all told is about 70 pages long. It also is available online. And I should mention it benefited from input from many jurisdictions, and in particular, I acknowledge Andrew Hadley and Angelo Greco here with us today. My former colleague Stacey Foyer also contributed to this. It was very much a collaborative effort. Next slide, please. The overarching goal of the toolkit is to support the implementation of the principles on cross-border enforcement that we've been hearing about. The 2003 recommendation in particular. And it does this by presenting relevant legislative actions that could be implemented or that have been implemented in countries to improve their ability to engage in cross-border enforcement cooperation, particularly where they may need to overcome a legal barrier to do so. And this responds to the specific need to overcome those legal barriers that were identified in the survey that we had at OECD and that many countries noted. Next slide, please. The toolkit sets out 10 guiding principles, and they're grouped into 3 areas, as you see here. First, investigatory powers. Second, enforcement outcomes. And then third, cooperation practices. And the first 2 areas cover the need for consumer authorities to first have adequate investigatory and enforcement powers at home. We're not going to be able to do internationally what we can't even do domestically. And there are actually a fair amount of detail in this on what kinds of powers one might have as a domestic agency that are helpful in this area. Under the other principles in these areas, the toolkit suggests what powers authorities might need in cross-border situations. To engage in investigation or enforcement with foreign authorities, foreign businesses, or foreign consumers. And then the third area on the cooperation practices looks at other forms of cooperation, in particular information sharing and the issues that I think Jason mentioned earlier about confidentiality. Finally, the toolkit contains an annex, and the annex in a way is one of the most interesting parts of it. It spells out the underlying rationale for each of the guiding principles. Why are these important issues? And illustrates how these are relevant in practice. We have examples from jurisdictions of cases and legislation implementing the guiding principles as we think about how do we actually deal with these concrete problems in a particular instance in practice. And these cover a broad range of economies and consumer agencies worldwide, from both OECD and non-OECD members. And we really were grateful from the contributions of those observer agencies as well. And the examples are not just limited also to consumer policy. There are also examples from other policy areas, such as competition, data protection or privacy, securities law, where the issues can be different, but are also often very similar to the issues that we face in the consumer space. And there are additional tips that are provided in connection with this document in the annex. Next slide, please. We'll take up a couple of these principles to focus on. First is the principle 2, which is the application of investigatory powers to assist foreign consumer agencies. And this guiding principle supports providing consumer authorities with the authority to exercise their powers to assist foreign counterparts in their investigations, which I think has previously been mentioned. The evidence, the players, the defendants or respondents, the money involved can be in any jurisdiction these days. So we need, as consumer agencies, the power to match that. Sometimes we don't even know where the wrongdoers are located. And part of the investigation is to figure that out. Sometimes key evidence for a problem that is in one country is located in another country. And the consumer victims can be spread around the globe. We had some comments earlier about sort of issues of complaint and complaint information. At my agency, the FTC, and with the multi-agency 9-language website, econsumer.gov, we've seen hundreds of thousands of consumer complaints involving cross-border transactions. And in the last year, for example, at my agency, there were 300 and some thousand online shopping complaints that were collected, and about 13.5% of those were ones where the consumer identified it as being a consumer from one country and a business from the other. And that doesn't even cover the consumers who don't know. A consumer doesn't always even know that they are dealing with a foreign business, or a business that may be domestic but has some international connection, and the like. Next slide, please. Here's a concrete, fairly straightforward example of this principle taken from the annex, and we had a case in which to assist the UK CMA, which had an action involving Viagogo, a ticket reseller. The FTC used its powers that were provided to us under what's called the US Safe Web Act. So I added this graphic about that. This was passed shortly following the development of the OECD 2003 recommendation that Brigitte has described. So we used the powers that we had there to go and get information about the investigation that the CMA had, and then provide that information to them. And that was, and the CMA then did secure an MOU here. And that is an example, very straightforward, but one of many examples actually that we have where we were able to share information and hopefully have a positive impact on the investigation for the other agency. Sometimes it can be the crucial piece of information. Sometimes it's just something that helps, but in a lot of situations we see this is an important thing for us to be able to do. There was a question earlier about the effect of MOUs, and I think, which Jason's answer I think was very helpful. The one thing I might add on that is the other thing that an MOU between agencies can do, and the FTC and CMA has an MOU, and we have some with others, is sometimes it can clarify what powers, in fact, the agencies do have currently, because that's not always an issue that the agencies can understand as to what powers the other agency has, or indeed, in some occasions, the agency itself may not have determined its position on their legal authority until they have worked that out. The MOUs can also address this sort of the kind of nationalistic or domestic focus that Hans Michlitz mentioned. Next slide, please. Another principle here is number 4, which is that enforcement powers to protect domestic consumers from foreign businesses. And here it's being able to take that action. And I think we've heard a bit about this from the previous speakers. And this could include the authority to bring actions against foreign business in courts of the authority's jurisdiction. It may not be enough to rely on the foreign jurisdiction, which to pursue. If I have my consumers being victimized by another country, by businesses in another country, that country's agency may not be aware of the practices, may not be well positioned to take action by itself, or may not really be in a position to make the matter a priority, this domestic focus challenge, at least not without help from the consumer's jurisdiction, hence the importance of the cooperation. And next slide, please. And this is a concrete example of that in an Australian case where the Australian, the ACCC took action against a US company. There was an argument that the law did not apply, but the Australian court said, yes, they can apply their law to a foreign business, even without a physical presence. The other challenge here, which someone has noted, is, of course, that the first issue is the kind of prescriptive jurisdiction for in this case, the Australian agency to take action in Australia. But then what do you do if you don't have assets or a way of reaching the company there? And there's the additional challenge of getting the judgment recognized in another country. And interestingly, since this example involves the US and Australia, I'll note that the US-Australia Free Trade Agreement actually has a section addressing, it's in Article 14, which refers to the OECD 2003 guidelines and provides for recognition and enforcement of judgments. At least it provides that it is not precluded by the mere fact that that a judgment that a consumer agency obtains is not necessarily considered as penal or revenue in nature or based on other foreign public law. Because one of the challenges here we have in general is the effect of the general international law presumptions against public and penal judgments being recognized elsewhere. And there is some law on this in some other jurisdictions as well. I'd also note that in the Hague discussions on the Convention on Judgment Recognition and Enforcement on Private International Law some years ago, there were discussions on the issue of judgment and recognition of consumer agency enforcement. It did not end up being part of the convention for various reasons, consumer issues in general, but I would note that that was a subject that was addressed and one of the challenges that we have been discussing here. Next slide, please. This is I won't go through this in any detail, but this is an example of the various countries that we have examples for in looking at these various principles. And there are examples from a range of different countries on how these work or sometimes don't work in the examples of the countries that we have. You know, what different countries obviously have had different challenges. And we sometimes have the challenge of agencies having some provisions, but the provisions don't fit together well. The kind of issue of the train tracks being a different distance apart, if you will, that we may have tried to design our provisions to be interoperable, but we haven't yet fully succeeded in that area. Next slide, please, which is another examples here from a range of countries on the notification and alerts issues, on the coordination and cooperation of investigations issues, where we have, I think, benefited from getting input from also the international networks, such as the ICEPEN, the International Consumer Protection and Enforcement Network. Next slide, please. At OECD, we're also thinking about the next steps. A longer term goal for the toolkit is to publish the toolkit in a web-based format, because since the examples are so important, being able to update this has a real value. And this kind of web-based toolkit approach is increasingly a common practice at OECD. It's been done for a variety of other OECD recommendations. This is an example from digital government. So this is something we can I think, aim to keep updated as well. Next slide, please. And furthermore, at the OECD, we're also seeking to improve the cross-border enforcement cooperation by learning from other policy areas. And so here we regularly cooperated with the Competition Committee, which has done work in this area, with the Regulatory Policy Committee, which has an interest in this area in a bigger picture way. The Committee on Digital Economy Policy, which has its working parties on privacy and telecommunications. There's a task force on financial consumer protection, where you have sometimes a different set of agencies that are working on these issues and also have this challenge. The Competition Committee it has, I think, tentatively scheduled for this summer a session on looking at enforcement cooperation, including in other policy areas. And I mentioned learning from others, but I would somewhat immodestly note that the 2003 consumer policy recommendation also was the source, had a real influence on OECD recommendations that were done on privacy enforcement cooperation and on spam enforcement cooperation. There are commonalities, as we have mentioned, to some of the issues that come up. And there are those documents as well as examples of regulators looking at how we can cooperate in these areas. The last point I'd like to make is to encourage folks to share the kind of helpful examples that we have already pulled together in the toolkit. I think sharing them with the OECD Secretariat, indeed also with the UNCTAD Secretariat, with the mapping project, and with this initiative as well from the folks at Reading. I think we can all learn from each other on this front. And I think the good news, as I mentioned, is that the UN and the OECD provide us with a consistent kind of general framework for this competition, but we have the challenge of focusing on the practical and finding the further opportunities for making this cooperation happen. Thank you.
Well, thank you so much, Hugh. Very, very clear, huge amount of information there. Thank you very much, but presented very clearly and succinctly. Really appreciate it. I mean, just to sort of double down on that ask from you, we are still looking for more examples to add into that toolkit. We have got a very good set of global examples, but as ever, it could probably do with being a little bit less focused on North American and EU examples, although there have been some very helpful ones from South American and African colleagues, but just to sort of encourage people, and if people have got examples beyond those mentioned in the toolkit or by you in the presentation, please do drop them into the chat, because we always want to hear more. Just before I introduce the next speaker, just to encourage people again to enter their questions into the Q&A. We've got a couple for later in the panel, but this is a really great opportunity to ask this splendid set of speakers some questions. So please do put your questions forward, and we'll do our best to get to them at the end. So on to our next speaker. I'm delighted to introduce Boniface Committee. He is an economist with over 15 years of experience of working and supporting African countries in particular at the national, regional and international levels, so interactions with corporate organisations, with the different parts of the UN system, and also with Kenyan government agencies in particular. And he's currently the manager for consumer protection at the Competition Authority of Kenya. So thank you very much for your time today, Boniface, and thanks for joining us, and over to you for your presentation. Thanks.
Okay, Andrew, thank you so much for this opportunity. And I'll be talking about the value and design of international networks and cooperation, giving highlights of some key lessons and best practice. And a lot of countries have made huge progress over the last 50 or so years regarding consumer protection. And we know that before the advent of the digital economy, a lot of consumer protection issues, was restricted to issues of trade. Resolution was within countries. Cross-border cooperation and international networks was either slow or non-existent. But the digital economy came in, and the economic crisis, and suddenly we were one global village. There is the advent of digital platforms, the social media platforms such as Facebook and Instagram, knowledge platforms such as Quora, media sharing such as YouTube, and service-oriented. We've been seeing Airbnb playing a big role in the world economy. Now, with this global village, suddenly, then we see we are sort of all connected. There has been economic crisis. We know COVID-19 opened up quite a number of issues regarding unfair, misleading, and abusive business practices across the world. There are issues of financial fraud schemes, such as phishing, etc. We know that a lot of cooperation or transactions are now global through the internet. We've seen the advent of online meetings. We are conducting this meeting online. E-commerce through Amazon and other platforms. Issues of digitalization are now on the lips of every human being across the world. The issues of cloud computing and biotechnology. Therefore, now governments have been forced to strengthen online means to reach consumers and to enforce laws. And it's now international networks and cooperation is more than needed. If you look at the design of international networks and cooperation is mostly within regional economic organizations. We've seen, for example, the African Union and the European Union. Cooperation is mostly bilateral. In Africa, for example, Kenya cooperates with other countries in investigations such as Zambia and our East African neighbors such as Tanzania. We've seen also in the European Union is bilateral, although it's also quite multilateral, but happening through networks, various regional networks. In Africa, for example, there's the African Consumer Dialogue. In the Americas, we see the Central American Council for Consumer Protection. In Europe, the European Consumer Protection Cooperation Network, and in Asia, the ASEAN Committee on Consumer Protection. But there's the need of collaborating or cooperating across the world. We have seen with the digital economy that we are all kind of connected. We know ISPEN is playing a very big and important role in bringing all the countries together to collaborate, sharing of information, sharing of experiences. But the question, the big question remains is in terms of enforcement, in terms of protecting consumers. Now, for example, in Kenya, we have had some sort of collaboration with other countries. I know around 2017, 2018, the ACCC shared quite some crucial information with Kenya regarding some investigations we were undertaking on a motor vehicle brand that had been recalled in Australia, which we were suspecting had been probably dumped in Kenya. And we've also worked in 1 or 2 cases with the Competition and Markets Authority, where one of a Kenyan consumer had been defrauded. So you can see in the digital economy, there's need for us to work together. I know the FTC through the econsumer.gov is doing quite a great job putting together complaints from across the world and trying to bring together all countries to be able to understand the nature of complaints happening across the world. I'll talk briefly about the state of cross-border cooperation, and I'm happy that Teresa Moreira brought it out through the consumer map, and I'm referring to the global consumer map, cross-border cooperation map by UNCTAD of December of 2020. And we see that only 39.51% have a cross-border or out-of-court or alternative consumer dispute resolution initiatives. And 60%, 60.49%, and that's quite a large percentage, do not have a cross-border out-of-court or alternative consumer dispute resolution initiative. And from that report, 40.54% have experience in cross-border cooperation on enforcement. 59.46% do not have experience in cross-border cooperation on enforcement. So it means that we have a lot of work to do. We have a lot of work to do, and I think this is one of the forums where we will need to discuss how, as the global village that we are, needs to come together to cooperate, to have the cross-border cooperation for the protection of consumers across. If we look at some of the emerging trends and challenges required for international cooperation networks to tackle, we have seen consumer issues arising as a result of the pandemic. Tourism and travel was affected. In Kenya, for example, there was a lot of flight cancellations. We had tourists or passengers from other countries whose flights were canceled. And through one way or another, they were able to send complaints to the authority to resolve. And the authority has been able to resolve some of those complaints. And you may take note that some of those passengers did not have to go through their consumer protection agencies in their countries, but they came straight to the competition authority. That means there's a way all countries are connected, and there's a way in terms of that we need to work together. There's the issue of international product recalls. I mentioned about the information that the ACCC provided with the authority, and issues of consumer product safety. International product recalls, how can we share information with other countries regarding those recalls so that the individual countries can take action regarding such products in their countries, probably there are certain batches that were sent across the world, and this information needs to be out there, and there should be a way where the cross-border cooperation in relation to international product recalls should take place. We see a lot of issues regarding data breaches and privacy concerns. Now, I mentioned we're a global village through the digital platforms, Instagram, Facebook, YouTube, and other platforms. There are issues of privacy concerns. Then how do we share such information? How do we get to know the type of investigations that have been done on those platforms in other countries that can benefit, especially the developing countries? So there needs to be some sort of conversation regarding that. And also on financial services and fintech. You know, Kenya is the pioneer for mobile money and sending money through the mobile phone. But there has been a lot of developments across the world regarding financial services and fintech. So we are talking about the payday loans, which are across the world, and fintechs are coming up every day, challenges coming up regarding fintechs and financial services. So there needs to be specific conversations and cross-border cooperation regarding this particular area. And this has been mentioned in the forum regarding best practice on the legal, regulatory, and supervisory frameworks. Most important is online dispute resolution. And how do we undertake market surveillance, joint market surveillance, and coordinated sweeps? I know ISPEN has been very vital in bringing countries together to discuss on coordinated sweeps and market surveillance. I would like to really focus on some of the key lessons, and mostly how UNCTAD as a global organization can better support our members in these critical areas. So how do we bridge the gap? How do we bring all countries to cooperate? I know they're doing a great job, but focusing on cross-border enforcement. Secondly, I keep mentioning that we're a global village and the issues of digital platforms, then how do countries collaborate or get to learn about the investigations of key consumer issues affecting consumers regarding digital platforms? And we know the regional frameworks. For example, in Africa, we have various regional frameworks. We have COMESA, we have the Southern African Development Corporation, we have Economic Community of West African States and other regional frameworks also in across the world. How do we come together to support these sort of frameworks to be able to come up with robust consumer protection mechanisms and also issues of global consumer redress tools? And this, I know, will be a focus of this conference, but this is a conversation that we really need to have in regards to online dispute resolution mechanisms. And obviously having effective and efficient measures to resolve such disputes online within various timelines. Thank you.
Thank you very much, Boniface. Fantastic presentation. Lots of really useful information. I thought the slide covering the sort of specific sectors and issues worth thinking on, I think that was really helpful actually, and I think that raises some very interesting questions about what we prioritize, whether we focus on the frameworks issues, which certainly the OECD work and UNCTAD work has looked at, I think, in detail, or whether it's that it's beneficial to look at some specific sectors and making kind of concrete progress there. I think that would be something we come back to at the end. So, but thank you very much for joining us today, and hope you can stay around with us. But thank you very much for your time. Just a last encouragement to audience to put your questions into the chat. I'm just thinking about which ones we answer when we've heard from the final presenter, who I will introduce now. So last in this session, but definitely not least, we're delighted. I'm personally delighted to see Angelo here today. Unfortunately, due to some political changes that have happened in the last few years, I don't get to see Angelo quite so often in person anymore, but very pleased to see him. Very pleased to see him here. So Mr. Greco is a qualified lawyer with international experience both in private and public sector. Joined the European Commission in 2006 and worked on as a legal advisor on consumer matters in relation to misleading advertising and the unfair commercial practices. In 2014, he was seconded to the US FTC to work on the enforcement of US consumer law, and he was then appointed deputy head of the enforcement unit of the Directorate General for Justice and Consumers of the European Commission. Before the Commission, he worked as an antitrust lawyer for a leading Wall Street firm in the field of commercial law and contracts, and he spent part of his legal training working for the merger task force for the DG for competition, so very broad experience. Thanks very much, Angelo. Over to you for your presentation now. Thank you.
Thank you very much, Andrew. I hope you all hear me loud and clear. And good afternoon to all the speakers and to all of those who are joining this conference from different parts of the globe. I thought I can contribute to this session by sharing some of the experience that the European Union has in enforcement cooperation field, including in relation to the challenges and the value of such cooperation. Now, as there is a lot to talk in this area, I will focus on one particular type of activity we carry out in the Union, and we think it's an interesting model, which could also serve as some sort of inspiration for in a wider context than the EU. And I'm referring to the joint enforcement actions of the Consumer Protection Cooperation Network of authorities, which we coordinate as European Commission. Now, to contextualize this, I will start, however, by recalling some elements of the enforcement architecture of our system and why we needed cross-border cooperation so badly in the EU. In fact, in the EU, we have a significant number of directives and regulations protecting consumers, and some even say we have too many. And consumer law is fully harmonized at union level, which means in practice that the same set of rules apply in all the member states plus the EEA states, a big group. And while rules are the same, however, enforcement is not harmonized. So member states are free to choose the enforcement system they find most suitable according to their preferences and legal traditions, as long as the means that they choose are effective and prove to be effective. Another important thing to keep in mind when we look at the EU system is that the day-to-day enforcement of union legislation in the consumer area remains a national competence. It is actually done by national authorities and courts in the member states. As the Commission, European Commission, we don't have any direct enforcement powers, but we do work hand in hand with the national authorities to support them in their enforcement efforts. And if we look at the challenges, of such a system, or the difficulties, as they've been defined earlier in the discussion today of such an ecosystem, we see that in addition to the general challenge, which is common to most jurisdictions, which is to ensure that enforcement is effective, in the EU we have a second, more specific one, which is to ensure that there is consistency in the way union law is applied across the single market. So having the same rules was not easy. It was already a result of a long journey that the union made. It was a challenge in itself, but it's not the end of the story at all. And it is paramount that such rules are interpreted and applied in the same manner, especially if we think that consumer law has many principle-based provisions, what is misleading, what is aggressive, how to apply this concept to new business models in the digital world, especially. If we think that the risk of divergences and discrepancies can be very high for a sort of a system like ours, where we have as many as 30 different jurisdictions involved, so EU plus EEA. And if we want to ensure an equal level of protection from consumers wherever they are purchasing, or wherever the traders are located in the EU, and a level playing field for businesses. So achieving consistency in enforcement outcomes is particularly important. And if we look in the EU, and if we look at global practices in digital markets, especially which affect millions of consumers in the same way, we believe that they can only be effectively addressed if there's a uniform and solid, compact enforcement response. In other words, if authorities in different jurisdictions speak with one voice. We don't want a situation where in the same internal market, where we have first circulation of services, workers, and capitals, we end up with different standards of compliance. That would not work. So we have seen in the EU that effective cross-border cooperation is really valuable and has actually a significant role to provide at least part of the solution to all these difficulties and problems that I mentioned. The first binding legal framework for cooperating in cross-border matters was adopted back in 2004, and it's the legal basis which we still use to cooperate is the Consumer Protection Cooperation Regulation. And the most important feature of this regime is that it introduced on the member states an obligation to cooperate. So under certain circumstances, cooperation ceased to simply rely on the goodwill of the member states, became an obligation. And of course, the primary objective of this was to bridge the jurisdictional gap in between the member states. So to make sure that a trader established in member states A targeting consumers in member states B could be stopped, and that traders could not easily circumvent enforcement by operating and moving along different jurisdictions. Now, the work we are doing, with the Consumer Protection Cooperation Network on this legal basis moved quickly from the embryonic stage of bilateral assistance between the member states to coordinated enforcement work, engaging the whole network of authorities at once, actually. And the flagship activities in this area have been the coordinated or joint enforcement action of the CPC network, as they call it. We have carried out a good number of these actions in different sectors. So against one global company or group of companies sometimes, such as internet platforms, but not only. And invite everybody to visit our webpage. I'm doing some marketing here now on these, which is called coordinated action, actually, when you will see all the sectors that we have covered, from social media to travel, car rental, accommodation booking. Now, during the pandemic, besides covering COVID-19 scams, we have engaged with 17 airlines at the same time to correct infringements related to cancellation of flights and reimbursements. We can say that this action has been successful. The capacity and the ability actually to carry out this action has greatly also increased over time in the network. And this is also due to the modernization of the CPC system in 2017. So we went from one action that per year, I think 2014, and now we are handling 16 actions simultaneously. So the network coordination with the coordination of the Commission. So the reform we had in 2017 introduced a specific procedure for these actions, especially when they're used to address union-wide infringements. And union-wide are infringements affecting at least two-thirds of the member states, accounting for two-thirds of the European population. The reform introduced new enforcement powers, it's been mentioned earlier today how power to intervene, to investigate, and to take measures is so crucial when we are in the digital world and we are talking about cross-border matters. And here we had, the reform introduced powers which are digitally fit. These together with a number of other improvements to the cooperation system. A consumer organization have been mentioned earlier, and under this system, they are now allowed to send alerts to the network for cross-border infringement. So this sort of cooperation, it's also in a way sees the interaction of multiple stakeholders besides, CPC authorities, which is also a very important features. There are rules to facilitate the exchange of information between authorities on cases. This has been mentioned also today as a difficulty. And the reform attributed to the Commission a mandatory coordination role when it comes to union-wide infringement, hence our sort of close involvement in the day-to-day enforcement. Now, if we look at how this joint action works in practice, the mechanism is quite simple in reality, and it consists of making a joint request by the CPC network and the Commission to a company or a group of companies to bring their practices in compliance with EU law, and to do this for the whole of the Union. So, as simple as that, actually. And such a request is generally articulated in what we call a common position, where CPC authorities set out a list of practices which they deem to be infringing union law, together with a legal assessment explaining why those practices are deemed illegal, and asking the company to address those issues. Now, if we look at the key strengths and benefits that we have seen in such a way of operating, I will mention a few. So these actions we've seen, they generate economies of scales. So we've spoken about resources of authorities and the lack of resources of authorities. They solve a problem in a sort of one-stop shop fashion for the whole of European Union. So member states don't need to employ resources, significant resources, and engage in multiple actions on national level. They can solve the problem just by supporting the common action, which is coordinated by the Commission, and where the burden is generally shared by a limited number of authorities in turn, depending on the action. We have actually seen that in this action it's rare that enforcement measures such as penalties need to be taken, given that there's a large buy-in of companies. So the companies comply voluntarily. And this is also saving resources for the member states, not having to undergo then the sanctioning, the litigation process following an investigation. Then this pooling of forces and this sort of close coordination allow the authorities to leverage the strength and the resources of the whole network vis-a-vis the company. These companies see a big group of guys coming after them, and that's proven to be quite effective. The companies actually on their side, they see similar benefits in this process as they understand that they avoid the risk of multiple proceedings at national level and reputational damages. This process also greatly contributes to legal certainty and consistency I was referring to at the beginning. especially as one of the main outcomes of this process is the preparation of this common position I mentioned. So these are actually common legal assessments agreed by all the enforcers of the union, and they are published. And then once they're published, they serve as guidance. And one of their objectives is to set a reliable sort of standards of compliance, across the EU, not only for the company to which they are addressed, but also for the whole industry, or that particular sector, which we think is very important. Now, for all these reasons, we are convinced that joint action, so this way of working with companies, is very valuable. And there is a potential to migrate also this process into more international, a broader context. As we believe that actually this action could work also with some adjustments, also for systems where there are no binding cooperation arrangements like in the EU. And I'm now thinking, of course, about networks like the international networks for consumer protection, the ISPEN, where we do not have binding, I would say, arrangements, and this is because, why do we think that these actions can work also in different contexts of the EU? Because the logic and incentives of the coordinated actions themselves are in themselves huge drivers for making these actions successful. So we have seen in particular, as I said, how powerful it is when a big group of authorities approach a company. And we don't see actually the fact that the laws in different jurisdictions are not identical as an unsurmountable obstacle to actually address global infringement. As generally certain conducts, or most of them, the usual suspects, of infringements of consumer law are indeed covered by all legal systems. So, and of course, using this action in a global context will also here help save resources and ensure a consistent outcome for what are global practices in the digital environment. And we badly need that, I think, at the stage where we are in the global trade economy. Now, I will end by saying that, of course, the Commission with the CPC network, we do many more activities than just these joint actions. So we do sweeps, capacity building activities for the network. We contribute also with the work of the network to other networks like the ISPEN or international fora like the OECD, UNCTAD. We were extremely happy to be able to contribute to the enforcement toolkit that Hugh Stevenson and Reid mentioned earlier. And technical abilities have been mentioned also by Jason Freeman of the CMA. In this area, the Commission is setting up an internet laboratory to be used actually by CPC authorities for digital investigation, which we think is also an interesting initiative. Now, the years of work with the CPC network have shown that the cooperation is sort of performant, but it's also shown that it's not perfect. So that there are some areas where improvements are needed. And we have started, I think it's a good opportunity here to say that we have started an evaluation process of the system to see whether there are grounds to review the CPC regulation again. And a public consultation will be launched soon. So I recommend that if you have any views, please respond. Your opinion will be extremely valuable, as we are here in a gathering of experts in this field. And once the result of this evaluation will be ready later this year, the Commission will decide then whether there are sufficient reasons to start preparing a proposal, which could be then published in 2023. And that's all on my side. Thank you very much.
No, thank you very much, Angelo. If I can sort of express a personal view, I very much miss the very effective work, the coordinated actions that you've just been talking about in the CPC, which the CMA was fortunately able to participate in before the recent decision to leave the European Union. So I very much recommend that people do get involved with that work where they have that opportunity. It's been very helpful. And I think very interesting, the final sort of comments around building beyond that CPC experience into ICEPEN, and I know and into other fora, I know that there've been lots of very useful discussions, very progressive discussions within ICEPEN about trying to learn from that and trying to take, for example, those common positions on sort of issues of common interest, like, you know, the way that privacy is used by platforms, for example, and apps, where, you know, I totally agree. The only way that we can deal with the sort of lack of resources in those areas is to work together, and finding ways of doing that where we don't have fully harmonized law, I think, really helpful. So the CPC is a fantastic starting point to build from, but also to improve simultaneously. So thank you very much for coming today. We've got a few questions, perhaps a few less than I'd hoped, but maybe people are keen to head off to lunch. We've got another sort of 10 minutes before so if I can first ask Hugh Stevenson to answer a couple of questions from Dr. Horner. I'll just read them out. So is it possible to mention some concrete legislative actions where the OECD toolkit has prompted or triggered in emerging nations so far? If not, could you please highlight the challenges identified? And then a secondary question from Dr. Horner. Would you mind informing us what the underlying reasons so far for not being able to implement the recommendations of the initiative? So a few quite tough questions there, Hugh, but I'm grateful for your thoughts on those, and thank you to Dr. Horner for your questions.
Sure. So yeah, thanks for these questions, which are both very interesting ones. In terms of the toolkit and where it has prompted legislative action, or maybe reading the question more broadly, where the recommendation, the underlying recommendations have prompted concrete legislative action. The context in which we negotiated the 2003 recommendation was at the same time that on the European Commission side, they were looking at what became the CPC regulation, and where in the United States we were looking at what became the US Safe Web Act that I referred to. There was then the Canadian Castle Act, which in turn I think had looked at both those provisions and some of the legislation that existed. I mentioned this provision in the US-Australia Free Trade Agreement, where it also referred to the enforcement recommendation issues. So I think this has been something that has been contemplated quite a bit in a lot of jurisdictions. I know in the African context, and there's in a little description in the annex about the Zambians and others working on the cooperation issues there. And we held an event, the FTC, where we had a number of participants who talked about the sort of development in that area, which is not, may or may not be legislative, but some of the challenges I think some agencies start with are, what do we need affirmatively to add to our powers? And other agencies, I think, frankly, particularly ones that have been around for a while, sometimes need to figure out what restrictions do we need to take away? And there's sort of both of those dynamics, I think, that exist depending on the agencies. My perception, and maybe Boniface would have a comment on this, but in some of the African agencies, it's had the benefit of their law has developed and in slightly later, and therefore some of these thoughts had already been part of the architecture contemplated, and that was, in a sense, has been an advantage. Anyway, the other question that Pierre raised was the recognition of consumer-related judgments. And this is a very complicated area, and I noticed that I think Professor Sommier had a comment here about this. The judgment recognition Hague work has a history from, I think it started in '92 and went on through whenever it was done, 2019 or something. This covered a huge amount of time. So there were various discussions along the way about various issues, including, as she notes, antitrust. But the thing I was thinking of was actually from an earlier time, which was looking at the limitations on public and penal judgments and how that intersected with consumer protection judgments, particularly those that where the agency was proceeding in let us say, parents patriae or something similar on behalf of consumers, or to obtain money in the form of a restorative remedy, and whether in some of those circumstances, excuse me, could be clarified that the recognition would not preclude those. And this sort of whole discussion points to one of the challenges here, which has come up in earlier, which is I think there's an intertwining of kind of private international law issues and private choice of law issues with public law and public choice of law issues here. And so those, I think, are some of the challenges that that come up in this area, as long as in addition to just sort of the general sort of questions about scope of the Hague work, which is its own whole story. But that, I think, has been part of one of the challenges here. The FTC has had actions where we have sought to pursue monetary relief in other jurisdictions, and have found in some countries that there is some receptivity to this kind of approach, and in some places some more limitations on it. So it is a sort of complicated area of litigation of seeking that kind of recognition. We've had some experiences, for example, in Canada of this kind of question, where we have had some success in getting some relief. I wanted, in addition to those questions, just to make one brief comment in response to the other question that our German colleague asked about the importance of consistency on the underlying laws as part of the story for enhancing cooperation. And obviously, it's easier if you have the same laws that you're enforcing or similar laws. But I think one of the challenges has been that isn't all going to happen. And so just because we can't agree on everything for the consumer substantive law doesn't mean we can't cooperate on anything. And to remind again, the sort of historical context of the 2003 recommendation was, it was focused on cooperation on fraud and deception issues. And why was that? I mean, one of the reasons was that that's an area where everybody had a little more substantive agreement. And so it could be an area where you could say, well, we do have some substantive agreement on this areas. Even then we run into problems of cooperation. How can we improve that? And we can work from there. But I think, as Angela also emphasized, it's not indispensable to have everything to agree in order to be able to cooperate particularly on a fair number of areas where we do have the substantive protections, but what we don't necessarily have are all of the mechanisms we need to cooperate in the particular cases. Thanks.
Well, thank you very much, Hugh. Fantastic answer. Just to sort of provide a little bit more of the background, because colleagues may not be able to see all of the detail of the questions. Werner Kannenberg from Germany asked about, effectively asked what is consumer. He's asked a number of more detailed questions than that, and I mean, I having had to answer that question to colleagues in central government more recently, it is a difficult question, even within the UK jurisdiction. What exactly does that cover? Do we have a narrow definition? And a lot of that is complicated by, as I discussed at the beginning, the kind of different legislative remits that enforcement agencies take forward. So, for example, the OECD committee that Brigitte was talking about earlier, and that Hugh is the chair of, has a working party on product safety, partly to recognise the fact that some of the participant agencies, including my own, don't have a product safety role, whereas participants such as the Australian Consumer Competition Commission, and we hear from Neville later, has got that role. And so it's very difficult. But I think I would agree with you that we need to try and agree on what we can agree, because a sort of comprehensive and full agreement of everything, I think, is extremely difficult, not least because the legislation itself is changing, as I think we've seen in answers to other questions. There's very wide-ranging proposals in a number of countries, and particularly in the European Union, for changes to the Digital Services Act and the Digital Markets Act, which will change the way that platforms are regulated. For example, we've been taking some steps in the UK as well, and there's many other initiatives globally. So I think at any given point it's very difficult to sort of draw a ring around something definitively. That shouldn't preclude us from reaching broader agreements where we can, and reaching common positions on specific issues. But I completely appreciate the challenges and the desirability of a sort of comprehensive arrangement, and indeed the sort of more substantive harmonization of law that would allow us to pick off many of these issues. But I think we have to think about what we can achieve short of that, because those sort of full and final settlement of all international law seem somewhat some distance away. Anyway, thank you very much to the panelists, and thank you to Dr. Horner and to Werner Kannenbo for their interesting questions. Thank you very much for that. We're going to take a fairly short break for lunch now before we return. If I can ask you to come back at 1:15 GMT, we'll start promptly then, but hopefully that gives you time to grab a bite to eat and have a comfort break if you need it. And look forward very much to the presentations and questions in the afternoon session. But thank you all very much for your participation so far.